It's more courtroom drama, and the court is now as caught up as we are as subscribers to this channel back in, let's say, the beginning of May, when I made this video. The hearing I'm covering was on Tuesday, and the occurrences that happened are important to grasp what's going on with the American lease sale because there are objections, and we don't know how that's all going to play out. But Fisker's future going forward is definitely on the chopping block. There's been a lot of activity happening around the case, like Fisker and Gita switching their salary to $1. Obviously, the mailers have started arriving to potential creditors, allowing them to file a proof of claim, and I have those videos posted on the channel already if you're interested in that information. This is not legal advice. Contact a lawyer if you have more questions. The hearing put some of Fisker's history on the record on Tuesday. I've also spoken with representatives from American Lease, and once the deal goes through, in the event that it is approved, we'll speak to them again here on the channel, so subscribe so you don't miss that. Also, there's no need for us to speculate on what happens with the deal because that's all it would be, is speculation at this point. And it will all be decided on
Tuesday.
That said, let's get to the case. First, the boring stuff that didn't happen in court, and that involves objections. The major objection is from the U.S. Trustee. The proposed sale lacks a valid business justification. The debtors have failed to provide evidence of the relationship between the proposed purchase price and the value of the assets being sold. In particular, the debtors provide no information regarding, among other things, their pre-petition marketing of a fleet sale, any attempts to shop the proposed buyer's offers, or competent valuation evidence. Number 2, the proposed purchase price is not fair. The sale motion continues the debtors' pre-petition practice of offering their fleet inventory to this buyer at fire sale prices without adequate marketing that would maximize value. Finally, the debtors failed to provide adequate and reasonable notice of the sale motion. The debtors sought a sale hearing for their crown jewel assets on 1 week's notice over a federal holiday and are exclusively pursuing a private sale to one buyer without any efforts to notify other potential purchasers. The debtors attempted to justify this expedited sale by representing that they would not be able to make payroll without immediate relief, but later walked that position back after, quote, revisiting, end quote, their books. And we'll get to that in this video. And in the same vein, Ideal Motors made an objection as well. Ideal Motors hired legal counsel to represent it in this instant bankruptcy case on July 11th, 2024. The amended notice of the motion entitled above was filed on July 10th, 2024, and set the deadline for objector to file this objection at 5 p.m. Eastern Standard Time, July 11th, 2024. There is a lack of due process for the objector for this motion. The motion was never served on Ideal Motors and its legal counsel. The objector lacks time to review and object to the motion without any notice, and for its legal counsel to review the docket of this bankruptcy case, who only today discovered the amended notice for this motion. Ideal Motors will supplement this objection as soon as it is able to do so. Ideal Motors reserves any and all of its rights without limitation. I agree wholeheartedly with the trustee's objection. Why did Fisker lower their price so quickly and so drastically? Was it in anticipation of this fleet sale? Or was that all the marketing Fisker intended to do? Either way, Fisker's going to have to prove they did enough marketing to satisfy the bankruptcy court. That said, let's get to Tuesday. We'll start with Doug Mantle, who represents the Unsecured Creditors Committee.
Let me ask if Mr. Mantle would like to be heard.
Thank you, Your Honor. Good morning.
Good morning.
The record from the firm, Forrester and Forrester. I'm proposed counsel to the official committee on unsecured creditors.
As a funny aside, Morrison Forrester's website is mofo.com. I got a little kick out of that. Mantle gets straight to the point.
Less than a year ago, in 2 separate transactions, Heights invested $450 million.
I'll use my 2-month-old video to explain what he's describing, as it's a little quicker. Once the rules within these notes are violated, that all went out the window. The default changes the conversion to a 25% premium when shares are issued. Fisker needed to file all of its financial documents on time. And if they didn't, a whole bunch of other options become available for these notes. This 25% premium gave Susquehanna's affiliates all the leverage they needed to walk away with shares under market value and immediately flip them for a profit. The future bad is that the first priority for Fisker's assets goes to the note holder. So on top of all the profit they've already gotten from the initial terms of the loan, the 25% premium, and the ability to short the stock, now in the event that the note holder isn't able to get 100% of the repayment, the notes also call for first dibs on all the assets. That's right, first priority for all of Fisker's assets. And because of the premium on the shares and the insider info that comes with the conversion, it's likely Susquehanna is already whole from this investment. Mantle confirms this suspicion that Heights Capital has already profited from Fisker and lays out more concerns.
Your Honor, the bottom line is that Heights invested about $450 million less than a year ago. And today, they materially profited from that investment and recovered more than their original investment. And then, yet today we have Heights as an alleged secured bondholder suggesting that they're owed more than $180 million and that their claims are secured by substantially all the debtor's assets. And this is because not only did Fisker's failure to file a 10Q a few days after it was due for Heights to profit from their self-help mechanism in their note, Fisker also purported to grant Heights various claims and liens, including claims and liens at subsidiaries that were not previously obligated under the note. It is because Fisker granted those liens, purported to grant those liens, that we find ourselves with a very real threat that Heights will prevent the debtors from using what Heights alleges is their cash collateral. But as everyone here knows, Heights' liens and claims are questionable at best. First, to the extent they exist, the liens and claims granted only a few months ago. Second, even if those liens and claims do exist, there's de minimis cash collateral existing today. The purported cash collateral in the future will be the proceeds of the sale of assets that are allegedly encumbered by Heights liens. Whether Heights liens encumber those assets, again, remains an open question. And third, while we've asked the debtor to provide us with certain basic information in regards to which Fisker owns the vehicles that are subject to the sale notice, they've been unable to tell us, to show us, in fact, which entity owns these vehicles. If Fisker doesn't know who owns the vehicles, how then were they able to grant liens on those same vehicles? We don't know sitting here today. Your Honor, the committee believes that the debtors deserve the opportunity to utilize the protections of the Chapter 11 process in order to maximize value for all equals. Adjourning the sale hearing the next week and approval of the interim cash collateral award that reflects the committee's comments is a very good first step. My hope is that we'll be back next week with a constructive path forward that will ensure a mechanism and a manner in which the debtor's assets are able to be managed in a way to ensure that all creditors' rights are properly protected.
The representation from Heights Capital has a different angle, obviously.
Good morning, Your Honor. Scott Kreisman, White & Case for Heights Capital. Your Honor, similar to the first day hearing, different law firm, same allegations, perhaps a little more dramatic. We don't think it's appropriate necessarily at all to respond to any of these allegations that Mr. Matt has stated on the record. We do have liens on the assets. We do have liens on the cash. Is it going to be an 11 or is it going to be a 7? That's the whole question here. And we're prepared to engage constructively with advisors on that front.
The U.S. trustee clarifies that there's actually a third outcome.
I just wanted to add to the mix that there is a third possibility here that could develop over the next week or two, and that is the Chapter 11 trustee.
Next, the debtor's representation clarifies that the need to accelerate was a little exaggerated, and some changes have taken place since the last hearing.
Much of the discussion at last week's hearing was about specifically exactly when the debtors would run out of cash to be able to fund payroll and other critical expenses. Since that time, we went back and sharpened the pencil and determined certain expenses that were able to be deferred. And we also had some unexpected receipts towards the end of last week. And when you put those together, they allow us to essentially get to a sale hearing on Tuesday, July 16th, which is the final cash collateral hearing.
Resnick also mentions a very important development.
I would note that we did receive one inbound of a potentially interested party. Of course, as we dumped on that and sent them an NDA. We don't know whether it'll go anywhere or not. We're certainly not taking our eye off the ball on the American leasing transactions. This is, as you know, a complicated transaction. It isn't just a sale of cars, but it also has all elements of performing recall obligations and things like that. So I would note, though, that for several reasons, it's pretty important that we get to sale hearing if it's approved as soon as possible and not further delay or release passing day, the debtors are incurring additional expenses and liabilities. This is a liquidation, and every dollar that gets spent is a dollar that's unrecoverable. And with every passing day, there's also unquantifiable risk. So we think the 16 strikes the right balance there.
Mantle then asks that the committee's objections be allowed through Sunday.
Again, given the fluidity of the situation for this committee, I would ask that the committee have at least until Sunday night to filing the objections. I don't anticipate sitting here today what those objections might be.
For the committee, Sunday night would be fine. And for the other parties, other than the committee, let's make it Thursday at 5 p.m.
And if you're thinking, sure, the unsecured creditors are going to object to the sale for one reason or another, you're actually wrong. They proposed an amendment to the sale which is way worse for Heights Capital. Reservation of rights of the official committee of unsecured creditors to the motion of debtors for entry of an order approving fleet sales agreement. There's only a few parts to this, spread out through over 30 pages, but let me highlight those. On page 13, granting related relief, as amended, modified, extended, or supplemented from time to time in accordance with the terms thereof, the, quote, cash collateral order, end quote, in the transferred vehicles as defined below, shall attach to all payments in respect to the proceeds of the sale transaction in respect of such purchased assets, subject only to the rights of any party in interest, including without limitation the committee, as and to the extent set forth in paragraph 10 of the cash collateral order, and to the carve-out and the permitted pre-petition liens, as defined in the cash collateral order. Application of proceeds. Any and all valid and perfected interests in the transferred vehicles arising prior to each closing date shall attach to any proceeds of the sale transaction immediately upon receipt of such proceeds by the debtors in the order of priority and with the same validity, force, and effect which they may have against such transferred vehicles as of immediately prior to each closing date, subject to any rights, claims, and defenses that any party in interest, including the debtors, the committee, the debtors' estates, or any trustee for any debtor as applicable may possess with respect thereof, including, without limitation, the rights of any party in interest as and to the extent set forth in paragraph 10 of the cash collateral order. Number 13 says all payments to be made to the debtors under the transaction documents shall in each case be paid into that certain deposit account known as the blocked account, and nothing in this order authorizes 1. The debtors to use any proceeds, 2. The pre-petition secured parties to exercise any remedies with respect to any proceeds, or number 3, any party to apply the proceeds in satisfaction of the pre-petition secured obligations as defined in the cash collateral order in each case, unless and until the court orders otherwise in a cash collateral order or other order as applicable entered by the court concurrent with or following entry of this order. So what that means is these amendments, should they be approved, would lock Heights Capital out of using any of this money. Number 31, the debtors are authorized to take any action necessary or appropriate to implement and effectuate the terms of and the relief granted in this order without seeking further order of the court, provided that nothing in this order authorizes 1. The debtors to use any proceeds, 2. The pre-petition secured parties to exercise any remedies with respect to any proceeds, or 3. Any party to apply the proceeds in satisfaction of the pre-petition secured obligations in each case, unless and until the court orders otherwise in a cash collateral order, basically hammering home the previous point. Number 34, nothing in this order shall be construed as or deemed to constitute, letter C, a waiver or impairment of any rights, claims, or defenses of the debtors or any other party's interest, including the committee's rights, to dispute the amount, priority, character, or validity of any claim on any grounds, basically bringing the committee's rights directly into the sale. Provided that nothing in this paragraph 34 is intended to or shall contravene or override any stipulations or agreements of the debtors or any rights and remedies that Heights or any other party in interest, including the committee, may have under or pursuant to the cash collateral order. The rights of all parties in interest with respect to the allocation of the proceeds among the debtors or asset classes is fully reserved and preserved. Way to go, committee. And that makes me very excited to find out how that's dealt with in the upcoming sale hearing. Finally, the judge asks about the water pump recall and access to future software.
Before we break, I do have one question, and really more to satisfy my curiosity than anything else. Is the warranty service being provided to current owners?
I'm afraid I don't have a concrete answer to that question, but it's definitely a huge focus of the company.
Okay, I understand. Thank you very much. And Mr. Shama has popped up as well, as I thought that he might after I made those comments. So let me hear from Mr. Shama.
Thank you, Your Honor. For the record, Daniel Shama on behalf of the Fisker Owners Association. Your Honor, I popped up only to echo the questions. I was eager to hear Mr. Resnick's response. It is an area of keen interest for existing vehicle owners, as well as for certain members of the committee at this channel referenced in his remarks. We have had discussions, we've begun discussions with the debtors around addressing that issue, not just warranty claims, but ongoing access to software updates and things like that. We hope to reach some kind of resolution on that issue, but it is obviously critical.
Again, this is off agenda, and it's really more for me to understand, but what people might be able to expect in terms of software support.
The only thing I can share is that it is very much a focus of the company and the various constituents, and it's very much a topic of discussion.
Certainly, I appreciate that, Mr. Resnick. Thank you.
So let's sum it up. The U.S. trustee has 3 objections. Ideal Motors, one of the consigning dealerships, has an objection, and it's basically, how did you do this so quickly? We didn't have time to look at anything. The proposed legal counsel for the Committee of Unsecured Creditors is aware that Heights was an unsecured creditor and transferred to a secured creditor, and basically, in an extremely short period of time, took over liens and claims to all of Fisker's assets. Software and recalls currently has no concrete solution for owners. As of the date of this hearing, which was last Tuesday, the sale hearing will be tomorrow, Tuesday the 16th of July 2024, and the Committee of Creditors, if their amended agreement is adopted, do approve the sale to American Lease, but only if Heights Capital cannot use the proceeds of the sale for their own remedies. And there you have it. The next thing going forward for Fisker's bankruptcy is going to be the sale to American Lease. Let me know what your thoughts are down in the comments. Join Patreon or become a YouTube member for early access to videos. Subscribe for more, and we'll see you on the next one.
Hey! Smash the like button!
Thank you.